So we are live. Hi, everyone. Welcome to another
Hello.
episode of Positively Family Law. Back to our regular programming with Heather.
I'm back.
So today we are talking about modifications, complaint for modifications, specifically if you are served with a complaint for modification, not necessarily you doing the modifying yourself. If you are served from the other party with a complaint for modification. So Heather, do you have like very simplified way of kind of explaining, what exactly that means? I guess let's like what exactly a complaint for modification is.
Sure. So a complaint for modification means there has to be a prior judgment, whether you've gone through a divorce and you have a divorce judgment, or you've gone through a custody matter and you have a custody judgment. There has to be something that was initially ordered by the court in regards to a final judgment. Now, you might have a non-legal agreement with your ex-partner about your kids, where you have a parenting time or a parenting schedule and you've agreed to pay so much in support or receive so much in support. If it has never gone to court, you're not going to be filing a modification. You'd have to start completely with a brand new petition or complaint. Only if that agreement was registered with the court can you then ask the court to modify. So it's basically what it sounds like. You're asking the court to change something that was previously ordered. Now, you usually have some idea that this might be coming, because if one person isn't happy with how things are, usually, not always, but usually they will talk to you and say, look, I don't like how this isn't working for me. I want to change it to this. So you have some idea that maybe they're not happy with how things stand. So if they're not happy and they want things to change and you don't want them to change, what they can do is go ahead and move forward and file a complaint for modification. So depending on what they're trying to modify, there's certain things that you need to be able to show. If they're trying to modify child support, the only thing they need to show is that if you run the numbers through the guidelines, that's a different number than what the current number is. If they're trying to modify a custody or parenting schedule, they have to show that there's a significant change in circumstances. There's some things that even if you want them to change, they can't change, because if the agreement, like let's say, for instance, with a divorce, if the agreement survived the judgment of divorce, that means you can't ever change it again. So unless for very, very few circumstances like fraud or coercion, it's very rare though. So if your agreement survived, even if the other person has filed a complaint for modification, then you have the grounds to file a motion to dismiss the mod. But typically, you're probably going to know that something's changing as long as your prior agreement merged with the judgment. It's able to be changed. So that's essentially a quick overview of what it is.
Gotcha. And I think a big thing, a lot of people are like, oh, I have a verbal agreement. That's not the same thing as if it's through the courts. Or even if something notarized is not the same as if it's submitted into court.
And we've actually had a few cases where people sign the divorce, the separation agreement. They think they're divorced, they move forward, they get remarried, they have other children, only to come to find out that that paperwork was never actually filed with court. And if it was not filed with court, you are not divorced. So you can't then modify anything. You'd have to start over. And if you're in that type of situation, it is a big mess. So make sure if you're going through a divorce, everything gets filed and the judge signs it off, because if they don't sign it off, you are not divorced. You're still married. And most people don't like that.
Great conversation that you're going to have. Okay, so let's talk about, let's say I get something in the mail. Now, okay, let me back up. Now, when you're being served, what is the proper, again, all in Massachusetts only, because that's the only state that, we're talking about in this situation. Let's say, using our example, we got divorced, okay, and we have 2 kids.
We're always getting together and breaking up, Kayla. We have a very tumultuous relationship.
Interesting, right? Okay, so let's say we have 2 kids. We have a parenting schedule, but your schedule has changed, so now you need to modify the days. You file a complaint for modification. How am I getting served? What is the proper way that I get served with this paperwork for a complaint for modification?
So the proper way is that you have to hire a constable. If you don't have the funds to do that, you can file what's called an affidavit of indigency, and you can ask the state basically to pay the costs, but you have to qualify for that. Typically, for anyone that has funds available, especially if you're hiring an attorney, they're going to assume that you have the money to be able to pay the filing fees. And for the constable, you need that complaint served in hand, or not necessarily in hand. The service processor may leave it at your address, but typically that's how it's done. If you just receive it in the mail, that's not going to, unless there's been a number of attempts of service and the court has given permission to solely mail it, it has to be served by a constable. So if you just get something in the mail, I wouldn't just ignore it, but perhaps the service wasn't proper, and you'd want to talk to an attorney about that.
So, and it doesn't count either if you yourself handed it to me.
You shouldn't. Can you fill out the affidavit that states that they served this? Yes, but whether you lied about it or not, you want to have it done correctly. So just hire somebody to do it. It's like somewhere between $50 to $100.
Okay, so now me as the person being served, what is the first thing that I should do?
So you read it. You always want to know what's coming at you. So read the documentation that was provided to you, and then more than likely hire an attorney. Get somebody on board, because there's different things that can be done. First, is there the appropriate burden in order to make the change that the person's requesting? Sometimes there's not, and you can file a motion to dismiss and make the whole thing go away. Other times there might be ways to negotiate and come back and just get it done very quickly. So then nobody really has to go to court besides to submit, some sort of stipulation to change things slightly. Then, the attorney can also, it's within 20 days of receiving the complaint for modification, you have to file what's called an answer. And what that means is it's basically reserving your right to be heard in court. Because if you don't do that and the court holds a subsequent hearing that you don't show up for, the court can just order anything that the other side is requesting. So if you want to make sure that for one reason or another, maybe you don't receive proper notice of a hearing, maybe you forget and you just don't show up, but filing that answer preserves your right to be heard and makes it harder for the judge just to kind of sign off on anything that the other side wants. What also you can do at the same time as filing an answer is you file a counterclaim. So there might be things that, based on what they're asking, you might want things changed. So maybe you've lost your job and you want the child support to decrease, and because you don't have a job anymore, you want more time with your children. There's a number of things that one person, it's kind of like, if you think of the big snow mountain and the little snowball starts and then it just keeps gathering and gathering, and there's more and more things. That's kind of what can happen within a modification. One person will say, I want to change this. And then the other person says, well, since we're going in anyway, I want to change X, Y, and Z. And you can do that through a counterclaim without having to start the entire new process of filing a complaint for modification. So you save yourself a little bit of money.
Good. Okay. So you mentioned the 20 days. Now, when does that start from? When does the 20 days start?
From the second you get served.
Okay. And now what happens if you don't submit a response within that 20 days?
You can eventually file a motion to allow for a late answer. But until you file that answer, the other person can also modify their complaint for modification. So they can just add some more stuff. There's a bunch of things that by filing that answer, you procedurally change things. And so if you don't do it in time and you're a little late, you can ask the court for permission to still do so, which usually isn't a big deal. But ideally, you don't want to count on it not being a big deal. So you just want to do it within the time frame provided, ideally that 20 days.
And don't wait until day 19 to do it.
Yeah, because that doesn't leave us a lot of time to actually put everything together. So, and then I think one of the things, especially with a modification, because the prior language of whatever judgment it was is so important, make sure you have a copy of your, if there's only one judgment, just that. But if there's multiple judgments, because you can go in for multiple modifications, over the course of time. If there's been things that, one judgment modifies this, another judgment modifies something different, or maybe another judgment modifies the same thing, you want to make sure that when you're bringing everything to a lawyer to review, they have the full picture. Because we've had people bring in like extremely old judgments that have been modified, and they're saying, well, this is what it is. And then it takes us a while to kind of uncover, no, you're wrong. There's been other things that have happened. So just make sure you understand what's going on in your case. And when the attorney, you're providing all your paperwork for the attorney, make sure you have it all.
Yeah, absolutely. So going into the actual modifications, if you're dealing with, let's say it's a complaint for child support modification, what is, kind of the first things that you should start gathering besides what you mentioned, your previous agreement, if it was modified previously, or your original agreement that both parties agreed on? What is something that you can get ahead of the game and have prepared if it's just regarding child support?
Yeah, so if it's just, and usually it's not just child support, but let's just pretend that it's very, very narrow and it is just in child support. You can start for any case that goes before the court that requires or is dealing with any financial issues, whether it's child support, whether it's extracurricular activities, whether it's, uninsured medical expenses. If it's a financial issue, the court is going to require financial statements by both parties to be filed. That usually has to be done before the hearing. So I would assume that if there's a complaint for modification, there's probably going to be a motion for temporary orders to change the child support sooner than later. So if you can start putting that all together, that saves that last minute rush of, okay, we need a financial statement, we need all your documentation. And then it's like pulling teeth sometimes to get the information at the last minute. So you can start putting together all your pay stubs. It's much easier if you're getting paid via like W-2. So if you get a paycheck, it's more complicated if you're self-employed. It's more complicated if, the reason for the child support change is maybe somebody got laid off from their job and now they're just collecting unemployment. And the question is, should they still be on unemployment? Should they be looking for another job? So there's certain things that you can do to, number one, prepare yourself and your own financial picture, but also to start asking the other side to prove theirs, because their financial picture is going to come into play as well. And that might be by getting some discovery done.
Gotcha. And now if it has to do with custody, is there anything specific that you can have prepared in regards to that? I think typically custody and child support kind of go hand in hand.
Yeah, you typically see at least 2 to 3 things. Most people don't go to court over one thing. It's usually a compilation of things where they're just like, okay, I have a lot of things that need to change, so we need to go back to court. Sometimes it is just child support, but it's more rare. Sorry, what was your question again?
If it's regarding like custody, is there anything, when you mentioned the financial statements and the financials in regards to child support, is there anything that you can kind of be proactive about gathering if you are served with a complaint for custody?
So a lot of times, and a lot of this is very issue specific, where if somebody's saying that, let's say, we have kids and you just never come for any of your parenting time anymore. You just don't show up. So I'm modifying it to say, I don't want to sit around every other weekend waiting for Kayla to maybe show up, maybe not show up. So I just want, the parenting time to change, because I'd rather be able to just go do my own thing. She's not coming anyway. So in that case, for my side, I'd want to show and have the text messages available that show you canceling or you not showing up. On your side, if I'm lying, you want to have as much to show that, no, I'm still going to see my kids, maybe on this weekend, I had to change things because of these plans. But if there's any communication or any sort of evidence that you can utilize to either prove your side or refute the other side, you want to start putting that all together as well.
Gotcha. Okay. And another question, you mentioned a little bit earlier in terms of like, you can't just file a modification because you don't like the way that things are. There has to be either a change of circumstance or a legitimate reason. Can you provide some examples that would be, obviously it's all circumstantial and it's very detail specific, but what are some general examples that could qualify for a complaint for modification?
Sure. So when kids are involved, it's an easier showing of a change because a lot of times the court will consider the passage of time a change in and of itself because life changes. What you plan for today in 2 years, 3 years, 5 years, your circumstances on both sides might be very, very different than what they were when you first entered into that agreement. So sometimes just the passage of time is enough. Not always, it depends on the situation. But let's say, let's say we have a baby and our baby's like 6 months old. So we enter into a custody program or a parenting schedule. And let's say you're breastfeeding. So you need to be with this child, more than me because I'm not. So if that were the case, within a year or 2 years or whenever the circumstances has changed that allow me to now have more parenting time, and maybe that's built into the original agreement. If agreements are done well, they can sometimes take some of the upcoming changes into consideration to try to keep you out of court later, without getting too detailed because of the fact that life does kind of change and happen. But if we hadn't dealt for that, and now I want to keep our kid overnight and you say, oh no, that's not what our agreement says, that might be something where I can say the circumstances were very different when we entered into that agreement from where they are now. Or, going back to if I have a job and I'm working 100 hours a week, I don't have the time to care for a child even 50% of the time, sometimes not even a third percent of the time. But if anything happens with that job and suddenly I'm working a 9 to 5 or maybe I'm unemployed, that might be enough if we live close enough to go ahead and ask for the parenting plan to be changed because now I have the time availability that I didn't have before. So, every case is going to be different. And that's part of what the attorneys are going to be looking for is what in this particular case, how have things changed in order to change the prior judgment?
Yeah. And child support is another thing. I think we have a lot of people who have called us and I'm like, well, I lost my job a year ago, so I stopped paying child support. You can't do that.
Yeah, don't just stop. You have to have an order that either decreases it or suspends it. If you just stop paying, you're going to get in trouble. So just don't do that. And if let's say you go ahead and file, but you can't get into court and you legitimately can't afford to pay the payment, because I have seen this happen. I've seen people that have incredibly high child support payments where something happens to their job and they can't keep up that amount. But even in those cases, and I am in no way by saying you shouldn't pay the full amount, not doing that whatsoever. But even in those cases where you can't pay the full amount and you're moving forward to make changes, try to pay as much as you possibly can. That, because even if you lost your job, the court could say, well, you still owe arrears, you still owe up until the point that the court changes it. So you don't want to be stuck. Number one, you never want to show that you're just ignoring a court order, and if the other side says, no, that's okay, you don't have to pay it for now, I understand things are bad, because believe it or not, sometimes that does actually happen. Make sure you have that in writing, because if anything happens, and especially if DOR is involved, DOR doesn't care, they're still going to be collecting that money regardless of what the other side said. But if, let's say I'm paying you $500 a week and I lose my job, and you say, okay, well, I know things are tough right now, so don't worry about it now. Just once you get another job, you can start paying me. Well, that's really, really nice of you. And that's our agreement, so long as we agree. But the second you get pissed at me and you say, oh, you owe me $10,000 worth of child support, you can file a complaint for contempt saying that I didn't pay that $10,000. And I'd have the defense of saying, well, no, she agreed to it as long as I could prove it. But it still doesn't necessarily get me out of the court action and owing that if then you go to look for it. So, of
course. And I think the other thing, people do lose their job. It happens all the time, and it is considered a change of circumstance. And that is where you be proactive. You file something in court that says, I lost my job, I can't afford this. And like you said, keep paying as much as you can, but understand that you can't just never get a job again because you don't want to pay child support.
Right.
And don't just ignore it and, be like, well, I don't have a job, so I can't pay. It is what it is. You have to be proactive with things like this because it will come back to bite you in the butt.
And I've seen a number of cases, and I think especially since the pandemic and things have kind of gone virtual, I've seen a number of cases, and even before, when things were normal, people would lose their job or change employment, and they'd go into court on a motion for temporary orders asking to decrease child support for one reason or another. And the court would say, well, I'm going to deny it now, but you can reserve it for later, because there might be questions around it. Did you leave your job solely to decrease your child support? Did you, what exactly are the situations? Are you getting paid elsewhere that maybe you're not reporting? So if there's any questions about it, and I think a lot of people get really upset because unfortunately this happens as well to people who can't afford it, and it might look sketchy, but it's not. And they end up continuing to have to pay a child support order that they really can't afford. And unfortunately that does happen. And I've seen people in court get really upset about it when the judge says, I'm not going to change this right now. And they don't understand, and I get it because it doesn't seem fair. If my income goes down and I can't afford child support and there's a reason to change it, you think, justice would call for it to be changed, but sometimes justice takes a while, so just be prepared for that as well.
Of course. And so one last question before we wrap things up. When you get served with a complaint for modification, does a court date get scheduled once something is filed, or is it after, the person who was served submits their answer? How exactly does the court date come into play?
So if there's no motion for temporary orders, usually the court will issue a pretrial date that will do that automatically. Depends on the court system. Some send that out pretty quickly. Others wait until there's an answer. Others, you have to actually ask for that to be assigned, and they won't assign it before it's requested. So it really is court dependent because each jurisdiction handles that slightly different. But if there's no, the quickest way to move a case forward is obviously to file a motion for temporary orders, because that gets you into court. If you can come to a full agreement, you can, write that all up, issue it as an order or issue it as a judgment, the judge approves it, and then you're done. So sometimes a motion for temporary orders is the quickest way to get things moving. And then usually whenever you have a hearing, they set down a next date. So you might have your hearing and then they set down a pretrial date, which if you just wait for them to assign it, it could take a while.
Okay. So rule of thumb, if you get served, read the paperwork first and foremost, understand what's going on, and then call an attorney. Talk to an attorney about everything. Don't wait till the last minute. Understand that you are on somewhat of a time crunch in regards to getting things going. And yeah, just talk to an attorney. I think that's the number one rule is if you're served, call an attorney as soon as you can. Don't wait until the last minute because it could just end up hurting you in the long run.
And if there's things that you agree to, so, don't fight just to fight. If it's something that's really not a big deal to you and you don't mind changing it, don't be an ass. Don't say no just because you want to be able to say no, because you're going to get drawn through this litigation. If you read through it and you're like, yeah, I could live with this, you know, maybe just talk to them about, how do we finalize this? Don't be afraid of that either. If it's something that you're completely against, that's a different story. If there's things that you want to have changed, and the other side says, well, no, I want my things changed and not your things changed, that might be a little bit different. But getting served can be emotional, and sometimes people feel as though they're being attacked by that. But try to take the emotions out of it, look at what's being requested, see if there's any room just to work things out. Because if you don't go through a prolonged litigation, obviously that's better for everybody.
Yeah, of course. And sometimes they can be, like you said, it can be emotional because you feel like, oh my God, like this person is just trying to put me through hell or something like that. But sometimes it can be a legitimate reason, and it's actually beneficial to everyone in the long run because of the situation. And again, everything is situational depending on you and your circumstance and your partner and your children or whatever is involved in the situation. So just kind of, like you said, take your emotions out of it and be realistic in terms of financials. It could cost you a lot of money if you're just trying to go back and forth with someone just because you're arguing. It's not really beneficial to anybody if you do that. And peace of mind as well. If you agree to everything but you just want to take them to court because you're pissed, like
yeah. And a lot of times on a modification, what I recommend is, we offer 1-hour consultations with an attorney who can actually read the language, can give you the pros and cons depending on who your judge is and what court you have as to what might happen if you go through court. A lot of times, we've had child support issues come in where, and this is more so, when the person's seeking modification versus responding to it. But we've had people contact us and they're like, I want to change my child support. And then we run the numbers, and the numbers were the order that is currently set were run on numbers that were applicable so long ago. And now, the person is making so much more money that the child support would actually increase. So sometimes it's worth it just to spend the hour, make sure you have a case before you go ahead and file a modification, because the last thing you want to do is file something that could potentially hurt you. But even with when you've been served with something, you're going to have to respond, one way or another. So there already is a court case. Before something's filed, I always say run it by an attorney and see, your pros and cons with something. Because I can't tell you, there's been a number of cases where we've been hired by somebody who's responding to a complaint for modification, and we look through it and we're like, we immediately file a motion to dismiss because of the fact that they're asking to change something that survived that judgment, so they can't change it. So save yourself some time and effort if you're going to file, and make sure you're doing it correctly. But then once you've been served, get an attorney on board pretty quickly, because they're going to know the process of making sure that you're protecting yourself.
Absolutely. And like you said, like a 1-hour consult, it's 1 hour out of your day, and it could make the literal difference of your case, especially if, like those people where filing that mod would actually do more harm and not achieve the goal that you want. So bottom line, always talk to an attorney when it comes to family law matters. Always get advice about your specifics and your situation before you make any rash decisions.
Yeah, and even if you can't afford an attorney, because I will be the first to admit attorneys are expensive, but even if you can't afford it, all the probate and family courts has a program called Lawyer of the Day. You can call them and find out when they have somebody available. You can sit down and talk with them. So even if you can't afford an hour consult, there's ways to be able to make sure you're protecting yourself. So do that.
Absolutely. Don't always trust Google. Talk to an attorney.
No, Google is not an attorney.
Yeah, the Lawyer of the Day programs are really great, and they can be really helpful. Even talking to the court itself in terms of like paperwork and stuff like that. There's plenty of resources out there that can give you the legal advice that you need from an actual professional and not just the internet.
But the internet knows everything.
Right? Of course. Okay, well, thank you guys so much for joining us, and we'll see you next week.
Thank you. Bye.